Hello everyone, this is Aparna Bhat and welcome to my YouTube channel Abhijna Legal Maps. So this is a new YouTube channel specially dedicated for those students who want to follow the lectures in English. So we already have a judiciary related YouTube channel in Kannada, that is Abhijna Law Series. So if you want to have a reference and if you are from Karnataka Judiciary, definitely you can subscribe to that YouTube channel Abhijna Law Series. So this is the alternative part of such channel where I will be conducting classes in English. Okay. So today's topic is as we all know, there are different we have three new laws where criminal reforms have been introduced through such laws. So one of such law is Bharatiya Nagarika Suraksha Samhita, which has amended CRPC. So we find different types of different kinds of changes which have been introduced, be it regarding the excessive powers given to the police, or it could be regarding audio video electronic means, or it could be the fixing of timeline or deadlines for a particular procedure, or some other miscellaneous matters where we can see that many changes have been highlighted. There are about like more than 100 changes if we count like one by one in a very small this one also if we count also, we can find many changes in such law. So going to the first coming to the first highlight. So Bharatiya Nagarika Suraksha Samhita, what I am going to do is we are dividing it into 4 parts. 4 parts we are dividing. The highlights I will be explaining in 4 parts. So this is the first portion, first part of that series. Okay. So the first one is, see here, first of all the name of the act is Bharatiya Nagarika Suraksha Samhita. The name has been Indianized, that is earlier it was Code of Criminal Procedure, now it has the word Bharatiya has been included. So Bharatiya Nagarika Suraksha Samhita 2023. So it has completely repealed CRPC and a new act is in place now. And coming to the definitions, so we can see here many new definitions have been introduced here. One is regarding audio video electronic means. This finds many places, about like 40 to 50 instances are there where audio video electronic means has been substituted. And regarding bail bond and bond. So provisions regarding bail and provisions regarding bail bond and bond, they have been defined in a well manner. And also electronic communication, this also has been added. And in the definition of victim, what do we find? It has been broadened by eliminating the requirement of the accused person being formally charged. So earlier the victim was to be considered as a victim, the accused had to be formally charged. Now there is no such requirement. There is no such requirement. Directly they can be called as the victim. So before the calling of such this one. So next one, an explanation has been added to the definition of investigation. So in the chapter investigation also we find different kinds of procedure. That is the largest chapter where many changes have been introduced as per the new law. So in the definition portion also, when it comes to the investigation, in case of provisions of a special act is inconsistent with the provisions of the BNS 2023, the provisions of special act shall prevail. So what does this mean? So we have investigation provisions in BNSS and there could be provisions regarding investigation under special acts also. So if there is any inconsistency with the investigating procedures, then the procedure as mentioned in the special law, special acts, that procedure regarding investigation prevails. So that is what the definition of investigation has been expanded. And comes to the next one. The post of judicial magistrate of 3rd class, metropolitan magistrate and assistant sessions judge. So earlier there was sessions judge, additional sessions judge, assistant sessions judge. Then chief magistrate, chief judicial magistrate and metropolitan magistrate, judicial magistrate of 1st class, judicial magistrate of 2nd class, judicial magistrate of 3rd class also they say. So all these categories, whatever the posts of magistrates or judges were there, they have been abolished. Now we do not find judicial magistrate of 3rd class, we do not find metropolitan magistrate, we do not find, and assistant sessions judge also we do not find it in the new act. Then under the next provision, so under section 15 of BNSS, the state government is now authorized to appoint a special executive magistrate. What does this mean? See here, different executive magistrates will be authorized. So, for some purposes special executive magistrate also can be appointed, and in such cases any police officer, even police officer can be appointed as special executive magistrate. So, that is one important point which you can see. Okay. So, his position, he must not be below the rank of SP, superintendents of police, or his post must be equivalent to, in addition to executive magistrate. Okay. Next provision is, a provision has been added in section 18(1) of BNSS to allow central government to appoint the public prosecutor or additional public prosecutor. So, a new provision which says that for the purpose of Delhi High Court, okay, central government can appoint public prosecutor or additional public prosecutor. And the next section is, in case of appointment of any other person in the absence of assistant APP. See here, a new timeline has been given here, 14 days notice. So, suppose the government wants to appoint another APP in the absence of original APP, any other person has to be appointed in place of APP. So, what the district magistrate has to give? 14 days notice to state government. That is the requirement here. Okay, 14 days notice has to be given. Next one, section 20 of BNSS established a comprehensive directorate of prosecution. So, earlier there was director of prosecution, but it was not as elaborated as such. The powers and all were not so, it was not very comprehensive. But under the new act, we can see the whatever the post or the authority has been entrusted to directorate of prosecution, it has been made very comprehensive. Okay, we can find various functions and different positions have been given here. And in the next section, the magistrate they were supposed to impose fines. So, they had certain limitations. Okay, JMFC could impose fine up to 10,000 in CRPC, but now it has been increased to 50,000. Similarly, JMSC was empowered to impose fine of rupees 5,000, now it has been increased to 10,000. So, in some states already there could be state amendments, but in CRPC the limit was 10,000, it has been increased to 50,000, and in this case JMSC from 10,000 to from 5,000 to 10,000. And another important thing, a new kind of punishment has also been introduced, community service. This has been introduced here, right. Next one, in the matter of sentence in several offences. See, earlier what was there, if in the operative portion of the order, if the judge wouldn't say anything about several offences are there, how the punishment would run? The punishment would run consecutively, one after the other, it would run one after the other. Unless he mentions, it runs concurrently. This was the case in the case of CRPC. But now the magistrate or the court, they have to specifically mention whether the punishment runs concurrently or consecutively. So, to be more specific, this provision has been introduced. And comes the next one, section 35(7). So, here this was the earlier provision of arrest, section 41 what CRPC mentioned, the same provision, section 35 of 7. So, here they have said that if in the case of aged and infirm persons, if they are suffering from acute illness and all, arrest cannot be made if they are, if the offence is less than 3 years, okay, and if the person is above 60 years or if he is infirm, if he is aged. So, in order to arrest them, they have to obtain the prior permission of the office not below the rank of deputy superintendent of police. They have to obtain the prior permission to arrest them. So, this is more citizen specific, as we can see. Then in section 37B introduced that there shall be one designated police officer in every district. So, this is a new post created, and he will be responsible for maintaining all the records of public details of persons arrested, and such details will be displayed through digital means. This is one another provision which has been introduced. And comes the next case is where when a private person arrests a person, okay, this was also this provision was existing earlier, but in the new act they say that whenever they arrest a private person, he has to be produced within 6 hours to the police station. So, if a person like you and me, if we arrest a person, we have to produce him within 6 hours of his arrest to a nearest police station. Okay, that is one important highlight. And in the earlier case, in the earlier CRPC, unless necessity required, handcuffs wouldn't be used. But now they have specifically provided in these kind of offences like who is habitual or repeat offender, or in cases like these kinds of offences, organized crime, terrorist act, etc. In such cases, handcuffs can be used. Okay, that is a very important provision we can say in this case. And then comes section 50, provides for the immediate seizure of the offensive weapon after the arrest is made. So, what it means is that whenever an arrest is made, even the weapons they could be seized, but the new provision says it has to be seized immediately, it has to be seized. So, there should be no time later. Whenever the person is arrested, whatever weapons were there with him, even they have to be attached or seized. The next change is in section 51, it has been provided that the medical practitioner shall without any delay. So, here there is a requirement for the doctor, whenever he conducts the examination of the accused or the arrested person, he has to immediately forward, without a delay he has to forward whatever the report of his examination to the investigating officer. Then is the next change is that it also provides that when already one medical examination has been conducted in police custody, still another additional medical examination also can be conducted. This is another case of new change. And the next change is about electronic form summons. So, the summons whatever the court issues, the format could be in electronic form, and also the service, how they serve, it could be through WhatsApp or electronic means, messages, email and all. So, it can also be made through service of service through electronic means, and for such cases the register has to be maintained. So, it provides for the issue and summons of service of summons, issue and service of summons through electronic means. Then we can see that see earlier when the summons was served, when a person who was summoned was not there at house, it could be served to the adult male member of the family. But now that section has been made gender neutral, and it provides that it could be served to adult member. It could be adult female member also, it could be adult male member also. So, that is why this section has been made gender neutral. And the next section is that in case of arrest under a warrant, section 82 in BNSS casts a duty on the police officer making an arrest to forthwith give information. So, when in outside the jurisdiction of the police station, if a police officer makes the arrest, immediately has to give the information of whom he has arrested and for what offence, and all these things he has to intimate it to the designated police officer of that place. So, this is more citizen specific, so that everyone must have the details regarding the arrest. And the next section is that earlier a person could have been declared as a proclaimed offender. So, proclaimed offender, when he could be declared, it was under a limited circumstances, but now proclaimed offender can be declared in cases where the offences are punishable with imprisonment of 10 years or life imprisonment or death. So, in all these cases a person can be proclaimed as proclaimed offender if he is not appearing in the court even after proclamation has been declared against him. So, this is one important provision. And the next change is that, see, this is regarding where outside the state, outside India, if any identification, attachment and forfeiture, this has to be made of a particular person. So, and that country or state is having a contract with India, then who can initiate the process? So, they say that it is the police officer not below the rank of SP. He can make a written request and he can initiate the process of the assistance from a court, okay, for identification and attachment of the property belonging to the proclaimed person. So, this was all about, we have discussed so far about 22 sections, 22 changes we can say. So, further we have 3 more parts of this particular video. So, if you are interested, definitely you can subscribe to this YouTube channel, and also we have a app that is Abhijna Law Series app in Google Play Store, you can download. So, as of now we have Kannada courses, but very recently, in a very short time, we are going to update it with the English lectures as well, and you may not get disheartened because we have study material in English. So, we have about 4 study materials in English, that is contract, CPC, that is Code of Civil Procedure, and Constitution, and also BNS, Bharatiya Nyaya Samhita, and Indian Penal Code. Comparative charts have been given in the form of a book. So, you can also purchase them through Amazon also. In Amazon, if you type Aparna Bhat Code of Civil Procedure, definitely you will find the books, or you can download this book, download this app, and you can log in and you can purchase the books through the courses as well. Okay. So, this was all about our BNSS highlights part 1. In the next video, part 2, I will be discussing some more important provisions regarding investigation provisions, where police have been empowered with many such powers where they can carry out the investigation in a very effective manner. Okay. So, if you like this video, definitely share it among your friends, and do not forget to like, comment, share and subscribe. So, I will be signing off. Thank you. Take care. Bye bye.